My name is Neil Fitzgerald and I'm the Head of Ethics and Governance in Chartered Accountants Ireland. As part of this governance webcast series, we'll be exploring a range of topical issues, ranging from board effectiveness, whistleblowing and speaking up, corporate enforcement and when it all goes round for companies and directors, and also a range of issues affecting small to medium-sized enterprises, charities, listed and regulated companies. And today I'm delighted to be joined by Gráinne Madden, Principal of GMG Associates. Following a corporate career, Gráinne has worked in the field of business ethics and corporate responsibility for nearly 20 years. She consults with and delivers training to organisations covering ethical behaviour, ethical culture, corporate governance, CSR, ESG, sustainability reporting and whistleblowing. In addition to her consulting and training work, she lectures MBA students in corporate responsibility in Trinity College and in Griffith College, Dublin. She holds an MBA and a diploma in corporate governance. Gráinne, you're very welcome.
Thank you very much.
Gráinne, I'm going to launch straight into it if I may. The EU Whistleblowing Directive, which is required to be transposed into Irish law by the 17th of December 2021, this will result in a number of enhancements to current legislation applying in this area. Can you please outline some of the key changes that boards and organisations can expect in this area?
Sure, absolutely. It's quite a lot of changes. Just to say as well, it's looking like it's going to be Q1 of the following year of 22. So there's maybe a little bit of extra time, but not much. The Protected Disclosures Act, as we have it now in the Republic of Ireland, is very much focused on protection of people who blow the whistle. There's really no requirement on organisations that are not, unless they're public bodies, to have policy and process and follow up on this. That's going to change. So organisations over certain sizes, and it's plus 50 employees, will be required to have policy and process. They will be required to follow up diligently on disclosures that have been made to them. They've got to respect the confidentiality of all the information and make sure they have confidential systems. They've got to have properly trained staff to do this. They need to abide by time frames in terms of feeding back to the disclosure. There's other things as well that they need to be aware of. One of the things I think that's very important and is going to certainly exercise a lot of employers is that if somebody who has disclosed, made a protected disclosure, later suffers retaliation and brings a case before the WRC or the courts, that the retaliation will be presumed to have been, due to them to making a disclosure. The employer will have to prove otherwise, whereas at the moment it's the other way around. The disclosure has to prove that they were retaliated because they made a disclosure.
That's quite significant.
It is very significant.
Yeah. And I suppose, Gráinne, the onus is on the employer to prove that any action is not in retaliation for a disclosure, but what type of documentation would you expect to be in place to prove that? Are we linking into performance appraisals? Are we linking into your 3-strike rule in terms of warning systems if somebody is dismissed or disciplined for some other issue?
Well, I think it's very important that employers are, to keep a proper record of all interactions. So, just because somebody makes a protected disclosure, it doesn't mean that they can't also be the subject of disciplinary action for for something different.
Yes.
But you want to make sure that both tracks are firmly documented and absolutely clear, and that there is no sense of the person being penalised. I actually heard a very interesting talk from a very large employer body in the UK, and the person who runs their whistleblowing process, they actually do follow up in this organisation and they do data mining to check whether there's any possibility of penalisation. They actually follow up and ring the individual some months afterwards to check that they haven't been penalised, because they want to make sure it's absolutely not happening. Yeah. And one of the key things to put in any policy is that penalisation is just not tolerated, and that it will, if someone is found to have penalised somebody for making a disclosure, that they will be subject to disciplinary action.
And so this is the broader acceptance that, speaking up and whistleblowing is in the benefit of the organisation.
Absolutely.
And it's something that should be encouraged, not discouraged.
Yes, I mean, why would you not want to know about a potential risk to your organisation? It's funny, isn't it? It's when you look at the logic of it, it just seems so clear that it's the obvious thing to do. But there still are, old, I suppose, myths and fears and concerns and that kind of disloyalty type of thing. So we do need to change our perspective. And again, actually, that same person I was mentioning, she spoke about turning it into a sort of it's valorization of the fact that somebody has actually blown the whistle. I thought it was a lovely expression to use.
Yes, that's lovely. Yes, and indeed, I think the legislation is introducing broader scope for protected persons as well.
That's true. Yeah. So and actually, at the moment, even in our current legislation, worker is very broadly defined, but we're going to see it much more broadly defined to include volunteers, which I think is a great move. I think that was unfortunate they were left out of the initial legislation, in my opinion. Particularly when we've seen some of the situations in charities, for example. I think they were often a source of good information. Also includes shareholders, which is interesting.
Yeah, and non-exec directors as well. Yeah, very good. And also the requirement is to have a variety of reporting channels, which is, so a single hotline is no longer valid.
Yes. And that's important. People need to have choice.
Yes.
Need to have choice about how they report and also who they go to, actually. But giving people choice about how they report. So it could be a hotline, it could be an email, it could be that you'll accept it in writing, or indeed that you'll accept it verbally, which frankly is actually how it generally happens. The reality is most people go to their line manager and say, I'm a bit worried about something. That's how it happens.
And it kind of acknowledges as well, and it takes account of the practical reality that somebody, when they have something to share or they want to speak up about something, they're probably in a bad place. And perhaps trust could be at an issue as well in terms of who they're reporting to. So having a number of different avenues to go to can promote or increase the likelihood.
I think you need to make people comfortable about where they're going. And I say that's why the reality is actually most people will go to their line manager. That is what the research would indicate. And that most people, it's not necessarily that people are actually particularly in a bad place. Sometimes they will be. They might have been very upset. They might have been mulling over something for a very, very long time. Sometimes they wouldn't even necessarily characterise it as whistleblowing, but they go with an issue, and it is actually whistleblowing. But that idea of, I suppose, who you trust and having the choice of where to go, if you're only given, say, the head of internal audit, and that person maybe seems to be a very senior person that's a very long way from you, where you sit in the organisation, that can be pretty scary. Or indeed, if you can only go to your line manager, and actually they're the ones who are the problem. You need to be able to get around that,
That's another problem. Interestingly, and just for our members in Northern Ireland and the UK, I mean, we're talking about the EU directive here, but I mean, interesting, the UK government have also signalled that it is reviewing its current whistleblowing legislation, and it's currently in the process of assessing the impact of the last reforms it made on the Public Interest Disclosures Act in 2017. But that raises another question I have for you, Gráinne, and it's given the fact that there are variances in the requirements by different jurisdictions, and many organisations operate in multiple jurisdictions. Is a one-size-fits-all policy and set of procedures possible when it comes to speaking up and whistleblowing?
This is the subject of quite a bit of concern at the moment, with particularly with multinational companies or have locations in various jurisdictions. So what would be, I suppose, my advice? I think you're going to have to do a bit of both. I think it is possible to have a one-size-fits-all policy in the sense of this is the policy of how we view concerns in our organisation, that we want to hear about them. I think you can put the policy certainly at a one-size-fits-all level and go with best practice, which realistically is going to be the EU directive view of whistleblowing. I think then in terms of the actual processes, that's probably going to need to be different depending on different jurisdictions. So for example, one of the issues is that the directive, and indeed the draft heads that we can currently see at the moment, indicate that employer organisations need to give staff advice in their procedures about where they go to report externally. So if you're, who are the likely regulators, or who are the likely, what we call them prescribed persons in this country, what do you need to know about going to them? Now, if you don't have that same prescribed person situation in another jurisdiction, or if the method of getting to them, or maybe the threshold that you've got to reach in terms of the disclosure is different, you need to be able to make those processes appropriate for the jurisdiction the person's in. So there is a layer of complexity. One of the ways I've been talking to organisations about that is to maybe have kind of advice lines. Now this is separate to your reporting line, but have a source of advice for people to go to per country, so that they're getting localised legal advice, if you like, about how to protect themselves.
I can totally resonate with that, because even the political systems in some countries, even across Europe, there is not a kind of unified basis of prescribed people that you report to. So it can differ. And actually goes back to the important point of legislation and what it is. Legislation is minimum requirements, really, and best practice builds upon that. And do you really need to have legislation in place to protect somebody valuable in your organisation that's taken the time to make you aware of something that's going on in it that you should be aware of? So even though a country mightn't have protected disclosure legislation, why would you not protect that person?
That's
anyway?
my view, absolutely.
Yeah.
Why would you not do? Because it just seems crazy to me. It's such a fantastic source of getting information before something becomes a disaster.
Yeah.
You know, and it's one of the things, in fact, that, you know, when we're training managers and you know, about thinking about how they receive disclosures or how they receive expressions of concern from the people who report to them, it is that be welcoming of it. Be glad to get it, and that can be difficult to do. In fairness,
it can. We can naturally get defensive when we're told something negative, and we feel like it's an attack on what we've done or the policies and procedures we're responsible for. But actually, it's the best way of actually improving them.
But if you demonstrate that you're, you know, and even if it's, you know, it's late on a Friday afternoon, you're thinking, really, I don't need this right now. You know, that could be what you're feeling, but you want to make sure you're not showing that, because if your body language shows to somebody, I really didn't want to hear that, that gets around.
Yeah.
That's much more powerful than any policy or process that's in the organisation. So it's really important that managers are trained to accept and think about, you know, the message they're giving to employees.
And that's a message that certainly echoes an earlier webcast we did with Dr. Margaret Cullen on behaviours and how they come across and how they influence. Absolutely. Grania, you raised a question there, or you raised a point about a whistleblowing or raising a concern. Can I ask you what might seem to be a very basic question, but you'd be surprised how commonly misunderstood it is, but when is a complaint a whistleblowing issue and when is it not?
This is one of the toughest questions, I think, and I think it is challenging for organisations. So essentially, you know, under the legislation, there are a number of descriptions of what constitutes a protected disclosure. And at a very general level, I would say it's something that's bigger than just you. It's something that it's not just about your personal terms, conditions, or your personal experience of the work. So it's not a personal grievance.
Okay.
It's not a complaint about, you know, my roster or, you know, something.
My bonus or my promotion. Yes.
Of course, it could, I suppose you could argue it could turn into one if actually there had been some mass discrimination involved in terms of how the promotions were organised. So then it could actually turn into one. And that's exactly actually a good example of why this is so tricky. Because sometimes what looks like a personal complaint actually has elements of potentially a protected disclosure or a whistleblower complaint.
So if it's systemic, is that?
Well, and sometimes it can be both. And that's the really difficult bit. Sometimes you're literally unpicking bits of, that bit's the personal grievance bit and that bit's the whistleblower bit. So you actually may, in some circumstances, be unpicking an issue and dealing with it under two different policies. That's potentially what can happen. So it's really important as well that managers are trained to recognise the potential for something to be a protected disclosure or a whistleblower complaint that may at first simply appear to be a personal grievance, and they kind of don't spot it as such and don't see the importance of putting it through the whistleblower policy as well. So it's absolutely key that organisations have a good assessment process built in. So it should be staged in the way that we deal with these things. And the first stage really after receipt of an issue should be to assess, what is this? What's really there? How should we be dealing with it? What's the most appropriate policy? Because just because somebody comes into you and says, I want to make a protected disclosure, doesn't make it one. But neither is it the case that it's not one if they don't say that. So it's really up to the employer organisation management to be very aware of that and be able to identify them.
And it sounds like a lot of this will happen at the management and senior management level. So, Grania, what does a board of directors need to be aware of in relation to whistleblowing, other than making sure that there's adequate policies and procedures? Is there anything else they need to be aware of? Do they get involved?
Well, I think that they need to be very sure that they have got adequate policy and procedure. I mean, I think that's an absolute basic. Okay, and I think they need to be careful that really, really is adequate. And I think there's a few ways you can actually test that out. From a board of directors point of view, my big concern would be, what's the culture of the organisation? Is it a culture where people actually do feel safe speaking up? and do they feel it's worthwhile? We know from research, and international research keeps on repeating this, that there are two main reasons that people do not speak up. One is they fear retaliation. So that's really what all this legislation's addressing, is to protect them from retaliation. But the other interesting thing is they think it's what we call the fear of futility. Why bother? They won't do anything anyway.
Yes.
So it's making sure there is a follow-up, that people actually see there's follow-up, and people, and that's why the directive is best practice in terms of follow-up and feedback to the person, because they're being told something's happening here. It hasn't just fallen into a void somewhere and no one's taking any notice of it.
Yeah, it's not window dressing either, that you have this nice policy and procedure, but it actually isn't effective, it's not implemented in the way
We also know that if people don't, if they feel something hasn't happened, and if they don't hear back, they assume nothing's happened, that means they then are likely to go outside the organisation. So it's also in the organisation's interest to make sure that they're aware something's happening, they're getting some feedback, and they're reassured. Not that we're giving lots of information, it's more we're on this. Don't worry, we're still doing it.
And Grania, owing to the confidential nature sometimes of the issues reported, I mean, is it fair for a board to ask, okay, are there any whistleblowing reports, live investigations at the moment we should be aware of? What is the nature of them? What is the subject matter of them? They can't really ask who are the people involved, can they?
No, no. I would say that would be bad practice, and there is a confidentiality. What I would be looking for from the position of a board director is I would be looking for trend reports.
Yes.
I would be looking for understanding the types of things that were being reported. I'm interested in the number of reports.
Yes.
For example, the famous case of Wells Fargo, where I like to keep the case that keeps on giving. There were reports that there had been 700 whistleblower complaints made about sales practices, which were supposedly sent up to the board, but the board said they never saw them. Now, again, why would a board not look for that kind of information in terms of risk? Yeah. They're supposed to be focused on risks, therefore that's a key indicator of risk, and it's a key indicator, I think, of where boards should be looking to do deeper dives to check where things might be going wrong. So if you see a big trend of a certain, there's a lot of whistleblower complaints about a certain topic, that we need to be going in there and doing something about that, or we need to check with internal audit what they're doing about it. The other thing I'd like to know as a board director is how many anonymous complaints I was getting, where people don't put their name to it. I would say if there's a very high percentage of anonymous complaints, that would give me cause to concern that people weren't feeling safe about giving their name to it.
Can you do much with an anonymous complaint? I mean, you're fairly limited in terms, can you?
You can do a bit. It again depends.
How can you protect the person if they're anonymous?
Well, you can't, and that's one of the issues. So ideally what you want to do is make it clear in your policy that you encourage people to give their name and that they can be assured of confidentiality. And also tell them that you can't really, it's very hard to give them protections if they don't give their name. But these days with technology, people could be sending it into an email with a kind of an email that's makey-uppy email that they've just taken, they've just got a Gmail. You can get back to them. You can ask them for more information. You can ask them to disclose their identity.
Also, with technology as well, you can also trace IP addresses and everything like that, so you could probably investigate enough.
Oh, yeah, but you shouldn't be doing that. Yeah, let's not go there. No, but I mean, you can encourage people certainly to come forward. And also, what you can do is, for example, if somebody comes on a hotline and won't give their identity, you can give them a case number, you can give them a password, you can ask them to call back to say get feedback. Or
so it's like an IT ticket, you can trace your progress.
Exactly.
Interesting.
So you can, there are things you can do. It's not necessarily the note with letters cut out of the newspaper stuck onto your door anymore. It's not that kind of anonymous.
We're not physically present anyway to do that anymore. Grania, the significant majority of companies in Ireland and indeed in Northern Ireland are SMEs. If you are director of one of these, bearing in mind you're an owner manager in most cases, what do you need to consider doing, and is it proportionate?
Well, as I said, companies over 50 employees will come under this directive.
That's the people that they're required to. But if you're
now,
an SME,
50 to 249, you have a little bit of time. You're given a little bit of time to put it in place. But in some industries, even smaller than lower than 50, you still have to do it. I think it's very tough. I do actually feel for the SMEs. I think it is very difficult. But at the same time, they also still need to get they need to understand the risks that are coming forward. One of the things that they probably could consider doing is maybe some outsourcing. So, for example, a lot of SMEs don't necessarily have a HR function in-house, but they may outsource and maybe have a retainer with a HR consultant who looks after their HR issues. I think something similar will probably develop for SMEs.
And is there a danger, because we talk about culture of organisations, and we talk about culture of large organisations, multinationals, and we think about financial services. We think about culture sometimes in the context of big organisations, but we forget that smaller organisations actually have very rich cultures as well. They tend to be owner managed. Directors tend to be very involved. They tend to be kind of treated like family enterprises and stuff. So is that as important in the small organisations as it is in the large?
Do you mean that they can get away without having these kind of policies? Or
I suppose that's actually what I'm alluding to. It's like they don't have the formal policies and procedures, but they've got the informal processes. Or do they need to formal up?
They will need to formal up. I think they will need to formal up. Now, I appreciate that they may have their finger on the pulse more about the culture of their organisation and know when things are going wrong faster. But I think they're still going to need to, if they're in that 50 plus category in terms of employees, they still are going to need to do this. There won't be a get out clause for that. So it is quite tricky, but I do think that there's a lot of good expertise out there. And I think that there's also this idea maybe that organisations can maybe come together and have sort of, shared hotlines. And by the way, if you contract say a hotline, if you've contracted them, that's still considered an internal disclosure. So there is that allowance made in the EU directive.
Gráinne, this is a very important area, hence why we're highlighting it in our governance webcast series. And I feel like I could talk to you for a lot longer about it. But I just wonder, as a closing question, is there any sources of information that our members out there, or indeed any director of a company out there, could go to find out more about this area?
Okay, there's a few sources I could recommend. Integrity at Work, which is a membership organisation. It's set up by Transparency International Ireland, who were very active in lobbying for whistleblower protection. And it was recognised when the Protected Disclosures Act came in that employer bodies also needed help and support with this. So Integrity at Work is that membership body. Now they'd have to join it, and as doing that they get access to advice, to consulting, to training, and full disclosure, I'm one of the trainers that delivers for Integrity at Work. So that's very, I think, helpful for organisations. There's also, in terms of maybe getting assessment services, so assessing the complaint when it comes in and how it should be dealt with, and if necessary, if an investigation is deemed necessary, which may not always be the case, there's an organisation called Raise a Concern.
Oh yes.
So they also they offer those kinds of services, and that's very useful, I think, for companies too, particularly smaller ones where you can't really do an investigation easily with somebody who's in the company. There's also information on the Institute of Business Ethics website. They'd have information about this. And there's also another London-based organisation called Good Corporation, and they have a whistleblower framework.
Oh, yes. Yeah, I've heard of them. Yeah. Well, Gráinne Madden, thank you very much for your time with us today and for sharing your insights on whistleblowing and speaking up, a very important issue that boards and organisations will no doubt be considering in a lot more detail when this EU directive takes effect. So thank you very much.
Thank you.
All the best.